Well, welcome everybody. Thank you for joining us for this seminar on tenant protections during the COVID-19 crisis. Every day we see the statistics and news from the outside world, and we worry about the state of our economy, our health, but also the state of our communities. There are many of people who are dealing with housing insecurity at this time, and so we wanted to put together this presentation just to highlight some of the new updates in municipal and state ordinances that have passed over the past couple weeks. So to start us off, I'm going to start off with a bit of administrative work. These are the community guidelines for this particular seminar. We're providing this for informational purposes only, and it should not be construed as any kind of legal advice. All participants will be muted, so please be kind, and you can submit questions through the Q&A icon at the bottom of your screen. The screenshot that you see is no longer up to date. There should be a Q&A icon where you see chat circled in that red area. And for everyone's notification, this session will be recorded, and we're going to be using this for future purposes, for future educational purposes. Fremont for Everyone is one of the hosts of the meeting. We're a community-based organization, and we advocate for inclusive, affordable housing. We also do a fair amount of community service and public educational events. And we wanted to put this together as a way to bring the community together during this time. And it gives me great pleasure to introduce my friend and colleague, David Bonaccorssi. For those of you who don't know him, David is a prolific community servant. He has formerly served as a city council member, a planning commissioner, and is currently a law partner with Bernard, Bagley, and Bonaccorssi. He focuses primarily on civil litigation, real estate and employment law, probate, personal injury, and appellate advocacy. We're very, very fortunate to have David as a key panelist and expert in this area. And without further ado, I'd like to hand it over to David for a presentation on tenant protections during the COVID-19 pandemic.
Thank you, Hayes, for the wonderful introduction, and good evening. Thank you for being here and listening to what is really an evolving and almost daily changing set of laws regarding tenant protection during the COVID crisis. And to understand where we are today, it's really been a conversation starting with our governor and then coming down to the levels of our counties and cities, where the counties have been exercising local control and the cities have been exercising local control. And we're going to be finding out that tension between what's been happening in Fremont, Newark, and Union City, and to find out, frankly, that what Alameda County is doing for now is really the rules of the road. But as I go through them, and I'll emphasize this again, it's good to know what our local cities have done, because it provides some grounding as to what Alameda County is requiring, which are much more tenant friendly and tenant protective. Governor steps in and does his own thing in terms of rent for residential tenants and at least banning evictions. But I'm also going to talk about what's happened at the state level with an organization called the California Judicial Commission, which has changed everything for the foreseeable future on protecting tenants and allowing tenants to stay in place. Next slide, please. On March 4th, Governor Newsom declared a state of emergency because of the COVID-19 crisis. And not only is that important as an entree as to what we're experiencing in our lives from a public health and safety perspective, but it also will act oftentimes as a marker for how long these protections will stay in place for tenants. There are other markers, but the state of emergency is often a metric or a time measurement for how long these tenant protections against eviction and deferral of rent are going to be in place. On March 16th, Governor Newsom issued an executive order, N-2820, giving powers to the counties and the cities to be able to enact their own bans on tenant eviction and defer rent. Before that time, before his executive order, those were matters, frankly, for the state legislature, and counties and cities did not have the power to set their own rules. But he opened the door to allowing this because of the state of emergency we're in. On March 27th, Governor Newsom enacted his own statewide ban, which will expire on May 31st. And that would apply where there's no local moratorium protecting tenants from evictions. Because we're in Alameda County, as you find out, we've had local moratoriums enacted in each of the 3 cities and now in the county. So Governor Newsom's statewide ban doesn't apply in our area because we have much more comprehensive protections. Next slide, please. As you're all aware, we've had shelter-in-place orders in Alameda County beginning on March 17th. We had one that strengthened the shelter-in-place on March 31st and was recently replaced by the one that's currently in effect on April 29th. That will be in effect through May 31st. And just this afternoon, Governor Newsom says he's going to relax some of the shelter-in-place guidelines, but it's very possible that the ones that we have in place in Alameda County and this as part of a 6-county consortium will still remain in place for our area. We'll have to wait and see. But this provides a backdrop for what we're discussing. Why are we having tenant protections now? Why is there such an effort by the governor and now by counties and cities to protect tenants? It's primarily a public health and safety issue. We're trying to reduce the transmission of COVID-19. We do not want at the same time to have people displaced out of their places where they live, trying to find other housing. We want to be able to provide a level of assurance and continuity for people who are experiencing job loss or maybe having to deal with the COVID crisis directly in their own families to be able to stay in place. So let's go to the next slide, Hayes. The governor, as I said, allows counties and cities to stop evictions and allows tenants to pay rent later. So what's happened here in very rapid succession is a series of regulations at the county level and at the city level, and then again at the county level. So it's kind of like watch the bouncing ping pong ball here. It's really quite head turning. On March 24th, Alameda County adopted an ordinance providing some protection for tenants in the unincorporated areas of the county. Unincorporated means that they don't live in the cities like Fremont, Newark, or Union City. They could be in Sunol or Castro Valley, Ashland, or Cherryland. It was very limited only to those unincorporated areas. In late March, our cities began to step in. Fremont, Newark, and Union City all enact local COVID-19 related residential eviction moratoriums. And as I said earlier, I'm going to be talking about them, but what happened on March 31st and then what happened as recently as April 21st really shifts the focus back to Alameda County. On March 31st, Alameda County enacted a ban on evictions that applied not only to the unincorporated sections of the county, but applies to Fremont, Newark, and Union City, even though Fremont, Newark, and Union City, as we shall see, had their own eviction bans. And then on April 21st, Alameda County went a step further and focused on what happens when the governor lifts the shelter emergency, or in the case of Alameda County, our health officer for the county says there's no more COVID-19 crisis, and you've had all of these tenants that have lost their jobs, can't pay rent or some or all of their rent. Suddenly they have to pay rent. What happens the day after? How soon can the landlord ask a tenant to collect rent? So the March 24th ordinance for the county, the March 31st ordinance for the county, it just focused on let's stop all evictions. April 21st is much more comprehensive, much more expansive, and says not only do we stop evictions, but we're also going to come up with a plan on how tenants can pay back the rent that they owe to their landlords during this period of time where we have the COVID crisis. There is a role for cities to play again. They can step back into the game of regulating, but they must show that their ordinance is stronger. They must show that they must do so in writing at a formal council meeting, and must specify which provisions of the county ordinance they don't want to participate in. Again, I'm not offering legal advice. This is informational purposes only. I can tell you, to my knowledge, that neither Fremont, Newark, or Union City has opted out, so we don't even have to begin comparing. But I don't think, my prediction is that none of them are going to try to do so, because I think, objectively speaking, if you compare and contrast, none of the three cities have ordinances that are stronger than the county ordinance. And what I mean by stronger is that the county ordinance provides far more protection to tenants, far more relaxed rules for tenants to be able to claim that they can't pay rent than any of the three ordinances that were adopted in March by Fremont, Newark, and Union City. So we now have, at least on the books, ordinances at Fremont, Newark, and Union City, but you have now the county swooping in, and we can talk about what that means, when rent is due and what you're trying to do in trying to qualify for rent relief. Yeah. Let's go to the next slide. COVID-19, the courts, and the county sheriff. I'm going to talk about the California Judicial Commission orders in a minute, but one of the practical effects of COVID-19 is that really the courts are closed. They're closed without talking about the California Judicial Commission. They're only open currently for domestic violence and civil harassment restraining orders, but that may change very soon. Today I actually participated in a civil matter for the first day that they were open in San Joaquin County. We called in, and there's more Zoom efforts. But right now the courts have been closed for the last couple of months. Alameda County Sheriff on March 16th, faced with a crisis, a pandemic, said, we've got other priorities. We're not going to evict any tenants, because the last step in the process is if a landlord goes to court, gets a judgment saying that they have a right to recover the residential unit from the tenant for whatever reason, generally because of non-payment of rent, the landlord will get a judgment from the court. The judgment is then enforceable by getting a writ of possession from the county sheriff. County sheriff will then go out and physically remove tenants that have not moved out by that date. County sheriff says, I don't care if you have a judgment, landlord. Again, because we're trying to keep people in place, we're not going to kick people out. Next slide. This was a real game changer as of April 6th, and this kind of explains what has happened to the county ordinance and becoming even stronger on April 21st. California Judicial Commission is not really well known, including lawyers, but it is presided over by the Chief Justice of the California Supreme Court and other appointed judicial commissioners, and they set the rules of court. And so what the California Chief Justice said is on April 6th, we're going to have emergency orders, and we're not going to allow a landlord for 90 days after the state of emergency is lifted by the governor. And as of today, the governor had 90 days, no landlord can go to court and get a summons issued. It's a magical document that the court clerk can issue, and only the court clerk can issue. You can't begin the process as a landlord of going through an eviction process unless that summons is issued, and the summons and then the unlawful detainer or eviction complaint is served on the tenant. So no matter what else has happened, if a tenant's not paid rent, whether it's COVID related or unrelated. Somebody moves out for reasons unrelated to COVID and you're behind on rent, but somebody remains. Landlord's hands are tied for 90 days until after the state of emergency is lifted. Means also there's no entry of default for 90 days. So let's say on March 10th, right before the shelter-in-place orders went into effect, you got you served the defendant. Tenant did not have had time to answer the lawsuit. They haven't answered it because the courts are closed. That landlord has to wait until 90 days after the shelter emergency is to be able to enter the default. Normally, it's only 5 days. The tenant only has 5 court days after being served with a lawsuit to file an answer, or they're in default. So if you serve somebody on a Wednesday, then you have Thursday, Friday, Monday, Tuesday, and Wednesday, and they have to file by Wednesday at the end of the court day, or else they're too late. So this is 90 days as opposed to 5 court days, and that's a long time. There's other delays that if there was a trial set before, it's going to be set at least 60 days later. There is one exception, public health and safety. So if a tenant was engaged in criminal activity or was, like running a meth lab or some other issue that was a public health and safety nuisance to the neighbors, the landlord will be able to go in sooner. Next slide. What are the COVID-19 eviction protections? Well, generally, what the ordinances did in Fremont, Newark, and Union City, and clearly the April 21st ordinance or moratorium from the county do, is they give tenants who qualify the right to defer rent, but they must pay back rent later. So far, there's no ordinance that has been passed in Alameda County or in any of the cities that says rent is forgiven. It just is going to be deferred, and we're going to talk about what the county does, which I think is quite interesting and very, very protective of tenants when we get there. Tenants cannot have their leases subject to termination or termination for non-payment. Now, again, there may be some efforts by a landlord to start the process by giving a 3-day notice. And under the county ordinance, they're going to have to notify the tenant of the rights under the county ordinance to not be evicted. And it's going to be in 12-point type, and it's a special form. But basically, that just sits there like a dead letter as long as the tenant qualifies for COVID-19 relief. And we're going to get into what that means. Eviction proceedings are delayed under the county ordinance and the city ordinances, but the California Judicial Commission has already created a delay for keeping the courthouse doors closed to landlords that want to evict their tenants for non-payment of rent. There are provisions that apply to tenants who don't qualify or timely apply for COVID relief. Those were true under the city moratorium, but as we talk about with the county ordinance, those are less relevant. You can be in violation again for a public health and safety issue or for some other non-payment issue. That can proceed, but again, you might independently still qualify for rent deferral. What we get down to with the county ordinance, we'll discuss again, but there's less distinction drawn between who can show loss of income for COVID-19 related reasons and any tenant who, for whatever reason, is not paying rent. Next slide. What now after the California Judicial Commission ordinances? I talked about the 90-day hold on any lawsuits started by the California Judicial Commission. There's something called AB 1482, which could be a separate presentation. But if you're a tenant who's lived for more than 12 months in your unit, if your unit is more than 15 years old, and it's not owner occupied in some manner, or it's not exempt, and the landlord has said it's exempt, you have a new state law that came into effect on January 1st that requires the landlord now to show just cause and give you a 3-day notice to cure before they can even give you a 3-day notice to pay rent or quit. So it's an added level of protection for many people, particularly in Fremont and in Newark, where there was no rent control at all of any kind. And in Union City in 2017, they did adopt just cause rules, and those will apply. But in all 3 cities, there really wasn't any rent control. So AB 1482 provides both just cause and rent caps that are beyond really the scope of this presentation, except I'll just say that no landlord can increase rent in Alameda County more than 5% plus the CPI, which was 4.1%. So you should not be getting any notices of rent increase. And because of the governor's executive order and because of state law, there's anti-gouging protections separately that even in properties that are not subject to AB 1482, no landlord can try to take advantage for whatever reason a landlord might to give you a 15% increase. And we're hoping that landlords recognize the market and the condition and the situation of their tenants and try to not play around with rent increases. There's also a practical reason that you should not be getting, if you're a tenant, a landlord giving you a 3-day notice to pay rent or quit, even if you're not COVID related, if you don't have a COVID related reason, because the landlord has to sit on that 3-day notice. Why would they serve it to you on you? Because if they accept rent on day 4 or day 10, or now with the 90 days under the California Judicial Commission after the state of emergency is lifted, if they accept rent at any time thereafter, then they have to start their 3-day notice all over again. They've waived their 3-day notice. So, and why would the landlord want to do it? I think the conversation there with the landlord is, don't you want to accept some rent if I can afford it, even if it's not the full rent, we can try to re-up and figure out a payment plan afterwards. But again, the Alameda County ordinance will give you some terrific protections if you're COVID related. There's now also a federal CARES Act. If the landlord has a loan backed by Freddie Mac or Fannie Mae, there's a 120-day moratorium from March 27th when the federal CARES Act passed, where they're not supposed to evict anybody or even give out any notices to vacate. So a lot of these, I'm semi-serious, a lot of these moratoriums place the burden on tenants to give documentation to the landlord. I think if you're in court, one of the things the landlord should be required to disprove is that he or she did not have a loan backed up by a Freddie Mac or Fannie Mae, and if they did and they gave you a notice that they can under some of these moratoriums, that may be an independent ground for invalidating the whole process, and the landlord would have to start again. Next slide. What if I'm a tenant, how do I prove I can't pay rent because of COVID-19 so I can pay rent later and not get evicted and not convicted either? Notify and document your reasons for your landlord, hopefully before, but soon after being served. These are general principles before I talk about the county rules, which are very relaxed. But if you do this, you're in good shape. The idea is to do it when rent is due, or if feasible, or soon after is feasible, and certainly try to do it before you ever get into a situation where you're served with a notice of termination. You must, under all these moratoriums, show a loss of income that's sometimes described as a substantial loss of income or an increase in COVID-19 out-of-pocket related medical expenses. So if you're uninsured and you had COVID symptoms and had to go to urgent care or emergency and pay out of pocket for it, that would be the kind of documentation that you or a family member that lives in that household could prove to say, look, I've had all these expenses, even if you've kept your job, as a reason to not have to pay rent now. There was a provision, I'm going to knock Fremont for this one thing. Fremont, I'm part of Fremont for Everyone. We try to advocate for this. There was a provision that you could have COVID, you could be out of a job because of COVID, but if you had been late on rent, not even had a 3-day notice, let's say you paid a day late twice in 12 months, the landlord could say, yeah, you otherwise qualify, but because you were a delinquent in rent for 2 times in the prior year between March 16th, 2019 and 2020, you don't get the benefit of any rent deferral, and I can still evict you as soon as I can. Well, that provision, it doesn't hold up on the county ordinance. That cannot be enforceable under the county ordinance in place. They don't make that distinction. And it was the only I've seen probably about 20, 25 moratoriums up and down the state. There were some good things about the Fremont ordinance that was good at the time that I can talk about that were favorable to tenants. This was the only ordinance ever saw that would ding anybody for looking at their past rent history. And our argument for Fremont for Everyone was, if somebody was already economically vulnerable, unrelated to COVID, they should be the ones that should most easily qualify for COVID-19 relief, because this was a tipping point for them. Anyways, because of the April 21st moratorium in the county, unless Fremont says that they're going to opt out, and I don't think they're going to be able to for reasons like this particular provision, that's not something that you should self-regulate. If you have been late on rent before, go ahead and start documenting and claiming COVID relief. The county ordinance ought to control. But I'll get into that a little bit more because it's really unfair to tenants and landlords to have 2 bodies of city law and county law swirling around in the same sphere. Next slide, please. What is a substantial loss of income? This is taken primarily from Fremont, but if you can show this under the Fremont ordinance, you can show this under the county ordinance. Reduced work hours, termination, or significant drop in pay that you can show from a letter from an employer, paycheck stubs, bank statements. This one was funny because this is true for all of us now. Child home from school closure. Well, I think all our children are home from school closure, so that should be an easy one to check off. For some reason, under the city ordinance in Fremont, they said extraordinary child care obligations from school closure. In my view, was anytime you have a child home that has to learn at home, that's an extraordinary obligation. Why they added the word extraordinary seemed to be over the top and could be an argument in court trying to measure the quantum of the burden on a tenant having to take care of their children. Anyways, under the county ordinance, they don't have that word extraordinary, and they do have school closure as a criteria. Other documentation. So you have other things that can show up that's fine, that you can document. In Alameda County, those are the kinds of things you have to show your landlord, but they go one step further. They say for whatever reason, you don't have the documentation, you can't gather it. Your employer went out of business, you can't get the letter, you never got your final pay stubs beforehand. You can do an affidavit under penalty of perjury saying you don't have the documents, but I as the tenant can show these other things that prove that I've had a substantial loss of income. And again, substantial out-of-pocket medical expenses, as I mentioned, due to COVID-19. This is also important, and I think if you have a letter to your landlord trying to show relief, you should remind them that the medical and financial information is confidential. They can't use it as a basis for retaliating against you. And explicitly, if you have a medical condition based on COVID-19, that cannot be a basis or a justification under any public health and safety rationale for the landlord to come back and say, well, you're a health risk. We're not going to try to get rid of, try to evict you because you're not healthy. You cannot use COVID, the landlord cannot use COVID-19 as a basis. The whole point is to keep people sheltered in place. Next slide. And again, Fremont, Newark, and Union City are instructive unless they opt out and can do so successfully. This is more for informational purposes. Under Fremont's rule, you had to notify and give COVID-19 related documents at the time or before rent was due, but not later than 5 days after being served with a notice to pay rent or quit. This was the most landlord favorable, tenant burdened ordinance of the three that we had in the Tri-Cities. You had to gather everything up, get that letter from the employer, paycheck stubs within 5 days. Newark was slightly better. You could have up to 7 days to notify your landlord, and then had 15 days after rent was due to get your documentation in order. Union City, similarly, was even better than Newark and Fremont. Just notify in writing and give COVID-19 related documents to your landlord 15 days after rent is due. But all of those are child's play in terms of the obligations that landlords can impose upon tenants. Tenants have far greater protections under Alameda County. Notify under Alameda County ordinance, the April 21 ordinance. All you need to do is, if feasible, as soon as thereafter, notify your landlord that you believe you're subject to COVID-19 relief. And then the clock starts ticking. You don't have to hustle around like in Fremont and make sure you give it in 5 days, or else you can't claim it and you lose all the protections. You can sit on it up to 30 days after the landlord requests it, or either upon landlord request or 30 days after the county shelter in place is lifted. Let me get more accurate on that. I believe it's 45 days upon landlord request or 30 days after the shelter in place is lifted, whichever is later. So under the county ordinance, you don't have to give documents at all. You could wait till trial if you go that far. Whereas under Fremont, Newark, and Union City, the landlord didn't have to request it of you. You had to figure out that you had to provide it. So again, this shifts the burden to the landlord. The landlord has to give notice of the ordinance in big 12 font type. And then then you become aware of it. Other than notifying the landlord then has to request it, or else you don't have to provide the documents. Again, this is informational purposes. I'm not giving legal advice. My suggestion would be document and even try to do it as quickly as the Fremont ordinance if you're in Fremont, because you're going to be in a situation where the landlord may believe the Fremont ordinance is still in effect. You can do it within 5 days. It removes any doubt that you've complied with Fremont. If you comply with Fremont's ordinance, you're in already with the county ordinance, rather than getting into a tug and pull with the landlord as to which ordinance applies. Next slide, please. These were payback. If I don't pay rent now, do I need to pay rent back later? When do I pay rent back? When do I pay back rent? After the COVID emergency? In Fremont, to its credit, it really did contemplate what happens after the moratorium was lifted, because the shelter emergency was lifted. And it had a payback plan that within 180 days, let's say you missed 3 months rent. Let's say 3 months rent is $9,000, just for the sake of hypothetical, $3,000 a month. That's pretty high, but it's not out of the range of some rents that we see in Fremont. You would have to pay $4,500 within 90 days, and the other $4,500 within 100 days after the moratorium was lifted. In Newark, they sliced it and diced it even more. It was the same 180-day period, but you had to do it in 25% increments within 45, 90, 135, and 180 days. Union City took a back seat, shortened it to 90 days rather than 180 days, but you could pay $1 on day one and $8,999 on day 90, and you're fine. They didn't have a payment schedule. But rent is not forgiven or forgotten in all of these jurisdictions, but there's a significant difference. In Fremont, Newark, and Union City, if you don't pay your rent on time after the deferred rent, the rent you didn't have to pay during the time that you had the COVID relief, if you were late on your rent, you could be current on your current rent, but you didn't pay back rent fast enough that you had deferred, the landlord under these ordinances, Fremont, Newark, and City, can give you a 3-day notice to pay rent or quit for the non-payment of the back rent that you have to pay back. And if you didn't pay it, you can go to court. What Alameda County does under its April 21st ordinance is it gives you 12 months to pay rent after the rent is due. So let's say you didn't pay rent in April of 2020. You have until April of 2021 to pay back the rent that was due in April 2020. It doesn't specify that it has to be all at once. You can pay a little bit at a time. Similarly, if you didn't pay rent in May, you have of 2020, you have until May 2021 to pay May's rent. Okay, so let's say you're going along, you're trying to just maintain the rent that you owe after COVID relief. You can't pay the back rent. You just get too far behind. Well, what happens is the landlord can sue you for it as an ordinary consumer debt, which means the landlord can't put that non-payment into a 3-day notice to pay rent or quit. The rent that was due during COVID could never be ever used against you as a tenant as a way of getting back possession of your property. So it's the first time I've ever seen. I've practiced law for 32 years. I'm familiar with unlawful detainers. Possession and rent have always gone hand in hand. This is the first time I've ever seen any jurisdiction separate the rent obligation from the right to possession. And so Alameda County is separating it out. One thing I should also mention about the moratoriums that we have is, who knows, somebody may successfully challenge the county ordinance. They may say the county has certain powers, but they went too far. So this is another reason to be cautious and at least be aware of the moratoriums that are still in place in your local jurisdiction. To, if you comply with them, you've got a fallback position in case the county ordinance gets tossed out as considered to be too tenant protective and somehow violating some state law in decoupling here, as we see, separating or severing the obligation to pay back rent from the right of a landlord to recover possession. What is true of all of the ordinances, whether stated or not, is no retaliation. Fremont was one of the few moratoriums that said that explicitly. There can be no utility or service reduction. There's no retaliation of the county ordinance, and that goes without saying. You should not be punished as a tenant, secondarily in some other way by the landlord for exercising your rights to be able to stay safely in your home and defer rent. Next slide, please. How long does the moratorium end in my city or in Alameda County? It's 100 days after Fremont declared a local emergency, which they did on March 17th. Eviction moratorium ends 30 days after local emergency ends unless extended. New York had other timelines, the latest of 3 things. But again, until the cities choose to opt out, which again, I doubt they're going to do, the Alameda County ordinance is the one in effect. It's COVID-19. For COVID-19 relief is until May 31st, 2020, or the executive order that I mentioned in an earlier slide from Governor Newsom, which also ends on May 31st. But if his executive order is extended, the county ordinance will extend as well. And all evictions, at least until 30 days after the local emergency ends. And let me emphasize this, I don't think I've done so previously. Remember how I mentioned in April 6th, the California Judicial Commission shut the courthouse doors for all evictions, whether COVID related or not. They didn't care, whether commercial, residential, of all kinds. On April 21st, the county, recognizing this, said, why should we just try to have tenants prove up COVID loss of income in order to be protective of evictions if the courthouse doors are closed anyways because of what the Chief Justice of California, the California Judicial Commission, has done. They've extended more eviction ban protection to all tenants, whether COVID related or not. The difference is there's no right to defer rent for non-COVID related tenants, and there's no right to then pay back that deferred rent over 12 months, but they cannot be evicted as long as as long as the emergency declaration is in place. There is an exception under the non-COVID related relief for a landlord to not wait 30 days after the local emergency, very similar to the California Judicial Commission. If there was a public and safety threat, health and safety threat, if it was imminent, they don't have to wait. If they remove their property under what's called the Ellis Act and go through that process and remove the rental property from the rental market, they don't have to wait. They can follow the Ellis Act to evict tenants. Or if there's a government court order that requires them to remove tenants for whatever reason, they separately, landlord can proceed sooner. Next slide, please. What happens if my landlord breaks the rules? Again, I wrote this before really emphasizing the April 20th, 21st county ordinance. But this is true of all of them, whether you follow the rules in Fremont, Newark, or Union City where you live, or follow the county rules. If you've documented your right to pay rent later and your landlord ignores it, you have defenses at an eviction, and which is an unlawful detainer trial. Separate defenses, and this really should say the April 21st, 2020 county ordinances may apply, and they do, and they're very powerful, and I'll get into it in a minute. Well, there's a defense that is an absolute defense if they didn't allow you to defer rent and they try to give you a 3-day notice and they ignored your documentation or never requested you provided it. This is an opportunity for you to get tenant advocates involved or attorneys, because it's in your interest, and frankly, it's in the interest of landlords to educate themselves about your rights and obligations so nobody's wasting time in court. Again, I want to emphasize, I'm not here to give legal advice. The facts and circumstances may be different in your particular situation, and now the county ordinance could not apply next week for whatever reason if there was a court challenge. So this is a snapshot in time. I believe it's useful, but I don't want you relying on any of this right now because there's so many moving parts. It's like three-dimensional chess. Next slide, please. Watch for future developments, okay? There's a bill called AB 828, which has been introduced by Assemblymember Ting of San Francisco, and there's some co-sponsors now. I believe Senator Wiener may have been a co-sponsor on the Senate side. And the landlord community is up in arms. And we'll see if it survives the legislature and gets signed into law. But what this would do, if it passed, would be for a tenant to go to court. And you could be a tenant that's never told your landlord that you had COVID-19 relief, never followed any of the rules under the local moratoriums or the county moratoriums, and go to court and say, Judge, here's my documentation that I really had a loss of income. And that tenant can bring it up, you know, on day one when the lawsuit's filed, even before he's served, or the tenant could bring it up at the very end before there's a judgment. You know, 2 or 3 days into a trial, say, Judge, I've got a piece of paper, an affidavit, I've got documentation. I should be given relief because I suffered loss of income. There are opportunities for a landlord to rebut it. If it's a small landlord, has 2 or few units himself as a landlord, he can show that he's also suffered a substantial loss of income. Tie goes to the landlord. If the landlord is a corporate landlord and has 10 or more units, or any landlord that has 10 or more units anywhere in the state, then that landlord is presumed not to have suffered a substantial loss of income, and tie goes, or the benefit goes to the tenant. Then what happens is the judge, if the judge makes a finding that the tenant did suffer COVID relief, ends the unlawful detainer, the tenant does not get evicted, and can order, and would be required to order, that the tenant pay 25% less rent per month for up to 12 months. So you can have, in particular circumstances, is a very lucky tenant. Nobody's lucky being in the middle of court trying to find an unlawful detainer eviction. I'm not making light of it. But if you look at it with 20/20 hindsight, you could have had a tenant, you could be a tenant that moved into your place, let's say in January, as a month-to-month tenant. You could have been evicted at any time on a 30-day notice. You enter into the COVID phase, you're unable to pay, you know, and then for whatever reason, or even if you follow the rules or didn't, you get into court, you have an affidavit, you've now converted your month-to-month lease into like a fixed term 1-year lease and pay 25% rent less than what you had originally agreed to pay. So if it passes, it will be another powerful tool for tenants to be able to not have to deal with some of the side effects of or major effects of losing a job or having COVID related illness. Alameda County, the county and we have panelists that have helped put this together, and Aaron Eckhouse and Lisa Steinbaugh, who you're going to see in a minute with the Q&A, and Hayes, who introduced me. We must have talked to the county 6 or 7 times about what rules are in place. And there was supposed to be a second reading, which is a fancy term for what an ordinance has to do. You have to have it introduced in one meeting, and in the second meeting, it's formally adopted after 2 readings at 2 agendized meetings. On April 28th, that was supposed to be even stronger than the April 21st ordinance. And what it was going to do was, what we've heard, I haven't seen the final language, is not even try to play ball with the cities. It would simply eliminate Fremont, Newark, and Union City from even the option of trying to opt out and saying we're the only county, the county ordinance is the only ordinance that relates to moratoriums in the county. We're eliminating Fremont, Newark, and Union City from even trying to have their own local moratoriums. It would then retain the 12-month repayment plan that I mentioned, and no eviction for non-payment of deferred rent after 12 months. And it would retain stiffer civil fines and a misdemeanor criminal violation that exists in the April 21st moratorium. A landlord that violates, this would be probably brought by the county council, the district attorney as a civil matter, as a civil fine, or certainly the district attorney as a criminal matter. A landlord can be fined up to $1,000 or $1,000 per violation per day. So let's say you had notified your landlord that you're subject to COVID-19. That really should stop the whole process. But if they go ahead and persist and give you a 3-day notice and don't give you the notice and try to play, cute that the county ordinance somehow doesn't apply, whatever it is, or even they try to go through the Fremont ordinance, they're violating the county ordinance by not abiding by the county rules. It's $1,000 a day from that improper violation of a 3-day notice all the way up to a trial, which is 90 days later. I mean, it could ends up being a high 5-figure fine. So I don't know if that's really clearly written, if it's enforceable. We want to have landlord deterrence. I have some problems with how broadly that has been construed. And then there's a misdemeanor criminal violation. A landlord can get prosecuted and serve jail time for violating the county ordinance. And I've never seen this before. I don't practice criminal law, but I did study criminal law in law school. And generally, before you can be convicted of a crime, in most crimes, you have to know that you're violating the crime, okay? At any rate, you could be criminally violated for violating that expiration, that ordinance. Look for May 31. What's going to happen to our shelter-in-place orders? What's going to happen to the governor's emergency order? State of emergency, when that gets lifted, this clock starts ticking on some of the moratoriums getting lifted. Look at San Jose. It might happen here. San Jose, rather than having rent increases, have now enacted freezes on rent. So no tenant can have an increased rent up through December. And then bottom line, you take all of this away. When you get into a situation with the landlord, make sure they know the rules, but work out some flexibility, hopefully with your landlord. You get in 12 months into the county ordinance, but you've got a lot of maneuverability. It may be an opportunity to have a discussion on discounts and even forgiving rent. Next slides. We're going to wrap it up and get to Q's and A's. I'll go through the few last slides here. I provided this as a California Association of Realtors form. I provided it here because it talks about a prepayment plan. But I now provide it to show you that this California Association rent repayment should not be signed by a tenant in Alameda County because it requires tenants to pay back sooner than they're required under the county ordinance. So if a landlord hands that to you, you should go to a tenant advocate and say, well, I think I've got 12 months. Next slide. This was a payment plan agreement provided by the California Apartment Association, approved form to a friend of mine who lives in Hayward just a couple of days ago. And it requires the tenant to sign to a prepayment plan. Again, this violates the county ordinance because it required a payment plan that would be much sooner than 12 months. You'll see here a due date of 6/30/2020. Well, they don't have to pay the rent for April until April 2021 or May 2021. He had not been able to pay the May rent. So this is on its face. Why should you try to get it? Why should a tenant agree to do something that the ordinance allows you to do 11 months later? And then it went beyond that and said, hey, in entering this agreement, residents under paragraph 5 says everything's, everything's fine with my unit. This is not a time to re-up whether your tenancy is habitable. If there's habitability issues, that's a separate issue. You shouldn't have to give up that right just to get a prepayment plan, which you shouldn't have to sign with anyways because of the 12 months to pay it back. And again, penalty of perjury, there is a requirement under the county ordinance to do it under affidavit to get out of paying rent because of COVID, but there's no requirement to sign anything under penalty of perjury to pay back the rent when you have up to 12 months. Next slide. And here we are. I know it's been a lot of information, but I hope sometimes I've done this. This is my 4th webinar already, and I've seen that in the Q&A sometimes issues that were discussed quickly can get discussed again and hopefully more clearly.
Thank you. Okay, first of all, I'm going to work backwards. So we talked about the May 31st lifting of the SOE, so forth and so on, and then having the ability to have the 12 months, which is more reasonable than, of course, the 3 months or from the other cities. And you said something about this is no time to bring up habitability issues.
Well, I misspoke. I don't mean that you shouldn't. What I was saying was there was a form that was requiring the tenant, in order to have a prepayment plan, to represent that there weren't any habitability issues. And I was saying that that form is unenforceable, should not be presented to a tenant in Alameda County because they have 12 months to pay rent back. You would have 12 months to pay rent back. You don't have to agree to it, and you certainly don't have to agree that your property is habitable at the time you pay back your rent. That's a separate issue.
Okay.
So if you have tenant habitability issues, absolutely as a tenant, bring it up. I said, if this is no time to bring it up, I meant really that this is no time for the landlord to bring it up to say that it is habitable as some sort of deal point in order to get a payment plan in place.
Okay, thank you.
Thank you for asking my clarification, yeah.
You're welcome. And let's see, eliminate the, so when will we find out, or what's the expected date for the AB 828 that would be?
Aaron can unmute himself unless he's got any better information. I think it's in the Senate right now.
So it's an assembly bill.
Yeah.
The assembly just now returned to the Capitol to take up the people's business there. We don't really know what is going to happen with that bill, is the honest answer.
Okay.
They look like they're going to try to clear all the bills currently in the assembly by the end of the month.
Mm-hmm.
So it's possible we will have new clarity by the end of May.
Okay.
But there's a lot of uncertainty.
All right. It's an interesting bill, and you know, a 25% rent deduction is a pretty large amount. I can't see that the landlords are going to let that fly.
One of the things,
Really?
one of my criticisms of that is not so much that there could be 25%, although that's certainly an issue for landlords, is just from understanding the court process. If you're going to allow a judge to make a finding that there is a substantial loss of income, that judge should have the discretion to be fair. So if somebody only really has a 5% reduction, the way it's written currently, it goes from 0 to 25. And and there's nothing in between.
Okay.
Is everybody else seeing?
Right.
Kathy Kimberlin apparently sent an email question, so I don't know where that email question might be.
It said to the prescribed email.
Sandra, go ahead.
All right, let's let me know if somebody else comes in. So at this point, basically, until Alameda County, and perhaps you can explain on who would challenge that for Alameda County.
You mean, well, there's two people that could challenge it. I mean, or two entities, two segments. Cities can challenge it in the sense they can try to opt out. But my view is, and I haven't seen any, first of all, no one's done it so far. I don't think that they're going to do it because I don't think any of them can objectively say that their ordinance is more tenant friendly than the county ordinance, which they'd have to show.
All right.
The second, who could challenge it? Landlord organizations could challenge it on what would be an immediate thing that would come to mind is due process grounds. It's a form of taking. That if you have a contract with a tenant where, you know, the one that may, again, I'm not forecasting that this will necessarily be the argument, but an argument could be made that the legislature has set up very, very stringent rules that in exchange for paying rent on time is the continued right to possession. That a landowner, when they lease properties to a tenant, divide the issue of ownership from the issue from the right of possession. But historically, and it's changing, historically, the courts have been most accommodating to landlords to be able to recover the possession of their residential units as quickly as possible because of the property rights of the owners to be able to have tenants that are paying rent or tenants that honor their contracts. What Alameda County has done, which is different than the moratoriums, has been to separate the issue of repayment of the deferred rent from the right of possession. So if you never pay the deferred rent, the landlord under the county ordinance is prohibited from giving you a 3-day notice to pay rent or quit for the deferred rent. That may be considered too far. And so if that's challenged or there's an injunction, something like that, that could happen that creates uncertainty yet again. And then, you know, what could happen, which is a nightmare, and I don't think the county is really thinking this through. It's, you know, it's week by week for the county. The county has basically supplanted or replaced the city moratoriums unless the cities opt out. Yet Fremont, Newark, and Union City did have ways of addressing repayment, but said it was still tied to possession, that if you didn't pay it on time, a tenant could still be evicted by a landlord after that time. So you could have the specter of a judge enjoining or stopping the 12-month rule from the county, but since the county ordinance is the only ordinance in place, the tenants could not fall back on the city ordinances for a prepayment plan because those ordinances have been wiped out by the county ordinance. So.
Thank you. Unless there's somebody else waiting for a question, I have another one.
Go ahead, Sandra. Let's
okay. Sorry.
You're on a roll.
First of all, yeah.
Yes. We do have 2 more questions that have been, I see Kathy submitted a question, and then I see Miriam has her hand raised.
Okay.
Would you mind?
Go ahead. Go ahead. Go ahead.
We'll circle back to you, and
Absolutely.
I'm going to put you on mute again, and then.
Absolutely.
All right. So Kathy asked, thinking about if there's work on a suspend and forgive mortgage program where the government might provide relief to mortgage holders, possibly in exchange for them passing down that relief to renters.
Yes, there is, and I didn't cover it here because that is a landlord issue, but the one I mentioned under the Federal CARES Act is Section 4024 of the CARES Act that protects tenants from evictions for federally backed loans, Fannie Mae, Freddie Mac. But Section 4023 specifically applies to landlords that are landlords of multifamily units. So if you are a landlord that has a multifamily unit, which is defined as 5 or more units under Section 4023, and you have a loan that's backed by Freddie Mac or Fannie Mae, you can get forbearance on your mortgage payments as long as you promise not to evict your tenants. Well, that promise is easily made in Alameda County because you don't have a choice, okay? So you should be able to qualify because you can just show them the county ordinance, say, I'm going to abide by the law, I'm going to do it. The problem so far, and I think this is a legislative solution in Congress that they really got to tackle, which is true for homeowners and landlords, is that all it does is means that on month 5 or whenever the moratorium is lifted, you have to pay all of your back mortgage payments all at once. So it's just kicking it down the road. But I think until Congress steps in, the most logical solution would be to tack those mortgage payments to the end of your 10-year, 15-year, or 30-year mortgage. So it really is deferred till the end of the day, and you could refinance and do whatever at that point. But right now it's a limited window. And certainly if you're a landlord doing that, you might want to give some rent forgiveness or rent discounts to your tenants, but recognize that you're going to have to catch up on those payments.
There's a proposal at the federal level for, I believe, $100 billion to help renters keep up on their rents, with the idea that that will then help, sort of flow through, help mortgage holders as well. It has not passed, but it's
right. You're hearing Congresswoman Presley from Massachusetts and some other more progressive Democrats promoting this. It's a good idea, but I think really to have any traction politically and also as a better policy idea, it's best to have landlords also be forgiven their mortgages as well, and not just be limited to Freddie Mac and Fannie Mae if they can, so that it doesn't just push it up the pipeline where landlords still have to maintain property or risk going into foreclosure and creating other disruptions for tenants. So there could be solutions in the short term which would give tenant relief, but would create larger problems for both tenant and landlord if both sides of the equation are not addressed equitably and fairly.
Else needs anything, I'll continue along with. Now, given that Alameda County is superseding, and within 2820, right? We have the 12 months, or anybody has the 12 months. So if June rent doesn't get paid, you make arrangements to pay that in June of 2020 of the next year.
Right.
Now, what happens if, this gets overturned next year?
That was the situation I just was talking about, possibly. It's hard to speculate.
Okay.
First of all, again, we should look at what the county does in May and June of this year. By all accounts, they're going to keep that provision in. But if they because they did not enact an ordinance back on April 28th, certainly landlord groups have become more aware of it and may have more time to organize opposition to it, or who knows what it's going to even look like in May and June. And it may look a lot more like the other moratoriums if county council is convinced that it may be unconstitutional. So that may happen just by the board itself retrenching on that issue. But let's say, this is just, lawyers love doing hypotheticals, but this was the hypothetical I was just thinking about. Right now, Fremont, Newark, and Union City's moratoriums are not in play because they haven't opted out. I looked at tomorrow's council agenda for Fremont, makes no mention of the ordinance. Frankly, I would, one way is I would love the 3 cities to say, okay, the county really is in the game. We're going to have a press release to make sure everybody in our cities knows that it's only the county ordinance that applies. We're repealing our moratoriums, in these areas because we don't want to confuse landlords and tenants, and whatever notifications went out from the cities to the landlords for their own moratoriums, I think it's incumbent upon the cities, in addition to the county, to get the word out. We're in the field. Aaron's in the field. Aaron's is fighting for the tenant rights, and we had some other organizations involved. We could not get a straight answer from the county as to what rules were in play. But to answer your question, Sandra, let's say the county keeps the 12-month rule in play, where it's just a matter of paying back as a consumer debt. And then let's say in February or March of next year, a landlord group, a property rights group goes into court and gets a court to issue what's called a preliminary injunction and seeks a permanent injunction. Preliminary injunction would be the court says, you know, I think you got a good claim, we'll have a trial, but because I think you're going to win, we're just going to suspend that part of the ordinance until such time as we have a trial on whether you prove up your claims. So if there was a preliminary injunction issue, that means that no tenant could take advantage of the 12-month deferral and there would be confusion. So at least with the city ordinances in play, you'd have a fallback position, but right now you wouldn't have any fallback position to any city ordinance because they have not opted out. So that could be yet another layer of confusion.
Right.
So I until we get there, I wouldn't worry about it. I think we're just playing this 1 week at a time, and we may have a clearer idea in May and June as to what the county's long-term plan is with their county moratorium, making it into an ordinance.
Correct. And just for the record, I've luckily have been able to pay these last 2 rents, so we are in no jeopardy at the moment. But that means nothing, day by day as well.
But
so
is there a danger of judgment?
But my question is would say for example that everything plays itself out, worst case scenario occurs for somebody and it goes into courts, is there a default judgment that will be put on somebody's record for evictions? I'd say
if the question relates to somebody not paying their rent, let's just say hypothetically this COVID relief goes from April, May, June, and July, and they're COVID eligible for deferring rent. And let's say it's lifted in July. So as of August, they got to pay their current rent, but they'll have April, May, June, July of 2021 to pay back rent on the deferred rent. If it's now August of 2021, September 2021, and they haven't paid their rent, again, under the a moratorium is currently written, a landlord cannot evict that tenant. The landlord can sue, and yes, if the tenant doesn't answer an ordinary lawsuit with an answer, a default could be taken. And yes, that would affect their credit, certainly, because it's related to their rental history. But they would still be able to live in their apartment or a residential unit as long as they continue to abide by their lease agreement and paid rent on time.
Okay, thank you. All right. I think that's about it for me. Let somebody else.
Thank you.
Thank you, Sandra.
Thank you very much.
I'm going to try unmuting Miriam one more time and see if we're able to. Miriam? I think there's something wrong with your mic or possibly your internet connection.
Sounds like an app.
Yeah, sounds like an app.
And
Miriam, you're certainly welcome to give me a call, or if you type it up, we can answer it.
This sounds like an app.
camera app.
So Miriam would like to know if there was a way to get copies of these pages, and yes, we can share around. There you hear the sharing around the presentation for attendees after as part of the follow-up.
Absolutely, yeah.
Is there any way I can have a quick question for David?
Of course.
Sure.
So it just has more of a broader summary question here. I'm a renter and I find myself potentially becoming in arrears. I have financial burdens, and I understand there's a lot of county and local and state legislation out there, but a lot of it is sort of in flux. And I know you're not trying to give advice, but what would be the best way? I can't afford an attorney. What would be the best way for me to both keep in my home, but also preserve any kind of economic damage to my credit in the long run as a result of this crisis?
That's a huge question, Hayes. I think that one practical way, obviously, is you wouldn't necessarily know unless you had a tenant advocate to instinctively look at the county ordinance. You might, erroneously look at the city ordinance thinking it still applies. If that was the worst thing that happened, you'd be okay because you'd be more than compliant with the county ordinance if you followed the rules at the city level. But if you should talk to the housing or email, I think on all of the websites, there's email addresses, email questions, and if they should point you in the right direction to the county ordinance and give you a copy of what is out there. It's not easy from a financial perspective. From a practical perspective, if you can, it's always better to pay some rent than none, because then whether it's treated as a consumer debt under the county ordinance or not, you don't put yourself in such a hole that you never catch up. And having, if you're trying to keep your credit rating fine, if you want to somehow pivot someday to be able to afford a house, these are credit issues that can hang over your head. And even though you may be given more relief now, if there's any way that you can pay some of the rent rather than all of it, you're going to be better off. Did I answer your question, Hayes, or was there some other aspect of the question that you were asking?
No, that's what I was asking. Yeah.
Okay.
Would you recommend that a tenant reach out and negotiate directly with the landlord during this time? Do you recommend that they seek some help in that process?
I think that they need help oftentimes. It depends upon the relationship with the landlord. One of the things that I thought forgot to mention, and I don't know if I don't think it's addressed in this county's ordinance, but I thought there was a real practical reality that Fremont addressed, and I know that the Hayward Moratorium addressed, that the county ordinance has yet to address, to my knowledge, which is how do you communicate all this? And the practical one is if you've texted your landlord under Fremont or Hayward, you're able to text this information to your landlord to claim rental relief or COVID relief, which I thought was, hey, that's a real world thing. If you have a good relationship with your property manager and landlord, then, really approach it as a situation that you're trying to solve a problem together. If it's been adversarial, then you really should realize that they're going to that either out of ignorance or deception, they're going to not play by the rules. Aaron had mentioned something that was real world to me the other day. So, well, you get to court, if they don't do it right and the 3-day notice is not right and they don't have the notice, you'll win in court. And he pointed out something that is reality, which is, if you don't speak English as your first language, if you're already scared and terrified, you may be on fixed income, you don't have all the resources available to you, and you might just leave and not know that you could stay. And that's the worst thing to happen, not only for the tenant in an individual case, but for the public health and safety concerns that we're all trying to promote. You don't want people suddenly displaced because they didn't know what their rights were. So absolutely reach out to tenant advocates, and there should be more of them now helping out tenants. And I'm going to be candid. I do this webinar for landlords, and I'm really saying the same thing to landlords. I said, this is not the time to play gotcha with your tenants, because it only bites you. If you have a 3-day notice, 3 days into the shelter in place, you're going to be sitting on that 3-day notice with no income for 9 months before you can get into court, realistically. So work with your tenant, I'm telling landlords. This idea that we hear, not necessarily consistently at the national level, that we're hearing from governors and local electeds and local leaders, is we're in this together. And if we have that as an attitude, that can be a bridge. If I'm a landlord and I've had a tenant that's had a stellar record, but now because they've lost their job for COVID-19, why should I be punitive? It's a pandemic. They didn't plan for it. We didn't plan for it. We're all suffering. Why take this opportunity to have a stellar tenant who's been there for a couple of years, has a good track record? Why destroy that relationship? And if you're the tenant that's been that good tenant, realize that you have a credibility when you go to the landlord and says, look, I've been good all this time. Now please work with me. And a lot of this, if it can be worked out and the tenant can do more than the law is required, but cannot be forced to do more than the law is required, it ends up being good for the landlord-tenant relationship and good for the tenant in the long run. So that's kind of just a more policy-driven, more 30,000 feet in the air kind of approach, rather than drilling down in each of these rules that we've been covering during this presentation.
I think that's actually one of the strongest things that could potentially come out of any type of dialogue is informing others what you've informed us today. If I could have a wish list that those who know their rights could find ways to express those who have the ability to negotiate with their landlords do so. I think it's about communication and it's about education.
That's what we're here to do, and I want to thank Fremont for everyone. Even though I'm part of this group, I want to thank all of you, Hayes, Lisa, and Aaron, for creating this opportunity tonight. And I think hopefully it's been informative. So.
Thank you so much, Dave, for this very informative presentation. Thank you to everyone for joining us this evening. Those of you who asked questions, thank you for your excellent questions. We will have a recording of this event available, and we will have David's slides available to share. We really do encourage you to share what you have learned today with others, because we know that there are a lot of people out there who are in difficult situations right now, and this is kind of information that might be able to help them. With that, I'm going to end the meeting. Thanks everyone for joining.
All right, great job, Dave.
Thank you. Good night.
Thank you.